Hello, returning humans. I'm so thankful that you're here. Thank you for joining me for some Karen Reed trial updates. So, things have happened. For all transparency purposes, I am not a lawyer or a legalese professional in any way, shape, or form. I am a legal enthusiast and I am a Karen Reed trial enthusiast. I've been following this trial since 2023 and I watched the first full trial in 2024 and have been thoroughly invested ever since. Everything that I'm talking about is publicly accessible information with publicly accessible sources. I will link to as many things below as I can. Sometimes I will link to videos that I have already made that will have additional information in links below. It just makes things more concise in the description box. But all of those things are accessible to you, and I will make sure to give them to you as directly as I can. So that is what's going on. So when I am filming this, it is after 1 a.m. on technically Friday the 21st, but I listened to everything and was listening to the trial things the last few days. I get off work at 11:30 p.m. and I usually listen to these things while I'm at work, just on my little speaker set. And so I take notes, and that is what is happening. Over the last few days, there has been a lot of stuff that has happened in the Karen Reed trial. So one of the big things that is very important is the start date of the trial. This trial, the second trial, was supposed to start in January. A continuance was granted until April, and jury selection has been set to April 1st, 2025. And both sides, the Commonwealth, which is the prosecution in Massachusetts, and the defense, have requested yet another continuance for various reasons. And the judge ruled today from the bench, which is insane for her, because Judge Beverly Cannone, the overseeing judge of the Karen Reed trial, has been renowned for not ruling on the bench. Even on minor, simple issues, she's been taking literally everything under submission, which means, if you don't know what that means she's like, I need time to think about it. I'll rule on it later. Let's keep going with whatever we're talking about here. But she ruled from the bench. She made an official ruling that she is going to disallow the continuance. Now, this is it's not surprising and surprising at the same time. The reason why it's not surprising is she did not grant a continuance when it was asked for in the first trial, and she gave a begrudging continuance already for the January trial date. So the idea that she would give yet another continuance, just not where she's been leaning towards. However, she also had made, because in the Karen Reed trial there has been a docu-series, I believe on HBO, I will put it here if I'm wrong, or HBO Max, whatever it is. But there's a 3-part docu-series about the Karen Reed trial and lots of players in it. And because of that, it has drawn even more national attention, garnered more attention than it already had, making it even harder to get a jury pool. However, she did make her ruling that she was not going to allow a continuance, but she did something very reasonable to try to balance out the needs of the lawyers needing more time. But what she was unwilling to do is she called the jury commissioner. This is what she said on the bench. And she said that they have been trying to assemble jurors and sort through jurors for months. And when she asked the jury commissioner how long it would take if she granted a continuance to find another jury panel, they said minimum 10 weeks. She is not willing to give another 3 months time to this trial. She's not pushing it out 6 months from the original trial date of January. So what she did do instead, though, she goes, we are going to continue with jury selection, continue with jury selection for April 1st. And we're going to begin the voir dire system. Voir dire in the courts is an interview questioning of the potential jurors to make sure that they don't hold any bias, because we want people to be as objective as possible in the jury panel. We want them to hear and listen to all of the evidence fairly and interpret that for themselves. They don't want any preconceived notions or ideals being pushed into the jury selection. And she said, we're not doing a 10-week out push. We're not doing that. And that would be the minimum. So she said, what we'll do is we will not swear them in. If a jury is not sworn in, then the defendant is not yet in jeopardy. Once a jury is sworn in, jeopardy applies, which means the defendant's life and freedom is in jeopardy. But she said, we'll take our time. It'll take 2 to 3 weeks. Because we have to go through so many people and the voir dire system. She goes, so that will simultaneously provide the time for the lawyers without interfering with her schedule too much. So that was a reasonable concession that she was willing to make, which was nice. And hearing her rule from the bench was also a nice breath of fresh air. The other kind of like pop-off thing that happened, which is also very implicating in the case, is that Michael Proctor has officially been fired, terminated without pay. He's not on vacation. He has not been given a suspended pay thing. That's not what happened to him. He is full on fired, gone, not allowed to be a police officer, detective, lieutenant, trooper, anything anymore. He has been dismissed. And with that being an official ruling, this is because there were motions made by the defense and countered by the Commonwealth about Trooper Proctor. They're like, listen, he's under investigation. And the defense wanted to bring that up. They want to be able to point out to the lead investigator getting fired or being under investigation for disciplinary actions related directly to the case. It's like, listen, you acted up here, you misbehaved here, and you called the defendant a C word here. Like, and you're getting in trouble in your workplace for that, because that's not just, some guy kidding around. This is a police officer not taking their job seriously. And the Commonwealth had argued, no, we're not going to bring that up. It's under investigation. They can't say, ooh, you're getting in trouble. We don't know if he's getting in trouble. They are looking into it. That's what an investigation is. They're finding out things. Well, the investigation has concluded now, and they have concluded with Proctor being concluded. He's done. He's done so. And this has a lot of other things for the Sara Birchmore case, which also comes into motions in limine as well. And they were just going back and forth about it. But now everything has to change, because since there has been something that has been publicly announced that, hey, our investigation is done, and Mr. Proctor, as Emily D. Baker had pointed out, I'm going to quote her, not trooper, not officer, Mr. Proctor, unquote, has been fully dismissed from his duties. And that's going to look really bad. It looks really, really bad for the Commonwealth to say, our lead investigator got fired because of how he handled this case, and like the stuff he did in this case was so bad that it led to his dismissal. It's hard to come back from that. And even if the Commonwealth tries to go the route of, you know what, we're not going to call Mr. Proctor to the stand about this, the defense team still can, and in order to get a cross-examination out of it, they can call him as a hostile witness. Hostile witness doesn't mean angry. When you have a witness that is being treated as hostile, it means you're treating them like a party opponent. So even though the defense is calling them, they're going to do questioning of them like they were called by the prosecution. So that's what being hostile means. It means still on opposing sides. And that is where we lead into the next big pop-off thing that happened, is actually during Kearney's case. Aiden Kearney, or Kearney, his name was pronounced several different ways in trial today. I'm going to go with Kearney. Aiden Kearney, also known as Turtleboy, was having his own trial with a different judge in the same courtroom and he has been related, and he had some arrests come up before, and he was let go, he was put under probation, he was let off of probation, he was prohibited in the original Karen Read trial. He is an investigative journalist, by the way, if you don't know who the peaches I'm talking about. Aiden Kearney, also known as Turtleboy, that is his Twitter handle and other social media handles. He's an investigative journalist who has been heavily critical of the Canton Police Department for many other things, including the Sara Birchmore. I will link a video that I did, which goes into all the details of that, and I will link it up here as well for all of those details. I just said that. I'm sorry, it's late. And so he was having a trial about whether or not his cell phones that he was using had to be turned over to Special Prosecutor Brennan in related to the Karen Read trial, because there has been shown to be evidence of Karen Read having phone calls and text messages over Signal. If you don't know what Signal is, it is a special texting app that basically stops your information from being shared. It puzzles it. So it makes it an enigma. It can't just be pulled from phone records. It is blocked and hidden. And so they were having conversations, text conversations through that app. And the Commonwealth is going a very different route in their trial by saying that these are things that indicate her guilt, that she was intentionally trying to, and Turtleboy was arrested and let go for charges of witness intimidation of mostly the McCabe and Albert family, and also Julie Nagel, or Nagel. I'm not sure how to pronounce it. I forget. But she is one of the sisters to like Jen McCabe and the Alberts, that they're family members still, just with a different last name. And that she was harassing the Alberts, McCabe, and their children through Turtleboy. She, being Karen Read, was causing harassment with the intent to intimidate. And Kearney has said, no, that's not what happened. I'm an investigative journalist. I was asking the defendant, who is out of custody, questions. So out of custody and in custody defendants get treated very differently in the system. And he was like, I was asking her questions, like stuff she knew. I was trying to ask the McCabes and the Alberts questions, and they were really hostile towards me. And he's saying, just because the McCabes and the Alberts, etc., don't like what I have to say and don't like what my supporters have to say, just because they don't like that Karen Read has a lot of support in this case, and that they are getting, Jen McCabe specifically had brought up a lot of harassment that had happened to their family and associates on social media and etc., because people think that there is a cover-up that happened just because of so many suspicious and unaligning things, and just the way the investigation was done overall. And Jen McCabe had indicated, and I will link to an article specifically that will tell you how Turtleboy connects to Karen Read even outside of the text messages. Jen McCabe, in her trial testimony, had stated things to Alan Jackson, who was cross-examining her, that, oh, you know Turtleboy, and oh, it's that blogger that you're very familiar with, the stuff that you guys posted on social media through Turtleboy. She was heavily indicating that the defense, and specifically Karen Read, had connections and affiliations to this investigative journalist, and that they were purposely trying to incite anger and get people to act out at them. She indicated that her daughter's car, Allison, that her car had been vandalized with semen, etc. And let me tell you, this is a separate thing. Please don't go real world with people. We need to ask people not to do something. Sometimes they do it, but it is not a good idea to go real world. That is what we have social media for. You can express your anger. You can say, I don't like Jen McCabe. I don't like the way Karen Read was treated. I think that the Canton Police Department is full of hooey. we can say that in these spaces and it not, I mean, they're not going to like hearing those things. Nobody likes hearing bad things about themselves or seeing and reading that stuff. Probably makes social media really hard when they're just bombarded with but we shouldn't go real world with people, okay? Don't stalk people. Don't harass them over the phone. Don't try to find their phone numbers or home addresses. Don't be sending them like dead rats or anything. Don't do stuff like that. It's not nice, and it makes it hard for the public to be allowed to have access to information, because it's like, yeah, we have to block everything because otherwise people will turn into maniacs. We are civil people, right? We are civil and polite. Mostly, you can still express anger and disagreement without physically attacking and harming people and interrupting their day-to-day lives. Okay? We have a court system for a reason. So that has happened, and that was part of the motion in connection to the Karen Read trial, was if Turtleboy was talking to her and Brennan wants all of this information, and the defense team for Karen Read just waltzed in the middle of a different judge, the judge for Turtleboy coming up to, and they came right up to counsel table like they owned the place, and the judge was not happy, and he made it very clear that he owned the place. The peaches you think you're doing, Alan Jackson. And Alan Jackson was the first one to be like, Your Honor, we have a right to be here. We said we were going to be here. The other judge approved that we were going to be here. And this is filed under the Karen Read case number. And whenever something is called under her defense, her file number, she has a right to be here and a right with counsel. Because since it directly relates that Prosecutor Brennan wants this information to implicate her and say that she was trying to intimidate the Alberts, McCabe's, etc., because she's trying to lie about their involvement. So it's all connected and overlapped and crazy. And then Thursday, today, when all of that was being argued, Judge Canone did make a written order later on in the day where she did allow, with limitations, Prosecutor Brennan's request. So it's like the communications between Turtleboy and other witnesses, including Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Julia Albert, Michael Proctor, Elizabeth Proctor, from April 8th, 2023 to October 5th, 2023. That is directly in the case file number of 2462CRZ0043 and 2382-C1-0313. So if you want to find those on Pacer, that's where you can look. He's also been allowed any videos or pictures depicting evidence of intimidation of witness in any way to any of the aforementioned family members, with the addition of Juliana Albert, and then any data dissemination, which means anytime it seemed like Karen Read was feeding Turtleboy information to get him to write stuff, would be, or like she was giving him information that was not otherwise already public information, because you can't be doing that, of any of the witnesses or family members of the witnesses involved. And it includes everybody who was already previously mentioned, from the same dates, April 8th, 2023 to April 5th, 2023, because those are the dates that Brennan specifically pointed out and said were relevant. And so it's like, yeah, you can turn this all over, but we're not giving you like just carte blanche. You can't just have at it. You can have these things from these specific dates that are directly related. You can't have everything. There was also continued argument over ARCA experts and other experts being allowed in, but the most interesting one is that Alan Jackson had proposed that they wanted another expert to be allowed to be brought in, and it is an investigative expert, someone who is an expert in proper police procedures and investigation procedures. And Judge Canone was mind blown by this suggestion, because she seriously was just, I'm sorry, are you suggesting that there is an actual field of expertise of how police investigations and procedures are properly to be done? Are you suggesting that? Yeah. And she verbatim said, I've never heard of that. I'm sorry, you're a criminal judge and you've never heard of proper police procedures? Okay. And she asked for examples of, and he said, well, we have, Alan, he being Alan Jackson, said, well, for instance, a lay jury, which means they're not legal professionals and should not be if they're in the jury. We're looking for normal, non-expert people to make the determination. But a jury will not know, like, yeah, we don't just use red Solo cups to collect evidence. And no, we don't ask all of the witnesses in the same group. We separate them. And she seemed completely bewildered and taken aback by this suggestion. And Brennan was just like, I really just don't know who this expert is. They just kind of threw him in there, and they said, no, our whole case is that this investigation was botched to begin with. We want to bring in an expert to explain and give the opinion of, okay, this is how police procedures normally go from here. This is how we treat crime scenes. This is how we treat witnesses, to question them. And that way we can then demonstrate that this is what is the standard, from our expert. And this is what the Canton police did. And that's a part of their case. It's a major part of their case. In fact, there is a specific point in moment in the thing where Brennan is sitting there going, I think that I'm going to have to proceed. And Alan Jackson just pointedly looks at him and goes, do it. The spice, the tea, the shade. So continuing on, we're getting close to the end. Everyone just hold on there with me. The other big thing that happened was Judge Cannone, they were arguing about things being turned over. She was very clear on earlier in the week, on the very first trial of the week, that she's still mad at Alan Jackson about the whole ARCA experts getting paid not being candid with the court. Now, it has been pointed out by multiple LawTube lawyers who are actual practicing lawyers that even though we might see that as a certain way, it is common practice for judges to really take more issue with candor to the court, like being open and honest with them as the judge, versus other discovery issues that might have other redeemable things. So even though they were trying to make Brady violations for dismissal, that the Commonwealth didn't turn over stuff, she was like, you didn't turn this information over to me, Jackson. And Judge Cannone and Alan Jackson have been very butting heads, because since this is not where Alan Jackson actually works, he's there pro hoc vice. Pro hoc vice is when a lawyer is allowed to practice in a certain state. Pro hoc vice lets them practice as an attorney in another state. Usually defense attorneys, prosecutors are usually, they represent the state, so they stay in the state. But defense attorneys have a little more leeway, so in this case, Karen Reed hired California licensed attorney Alan Jackson to represent her in Massachusetts. That was not revoked, and she was acting like it. Judge Cannone was absolutely doing the, you violated this, you didn't give me candor, and you keep coming at me about it. But she didn't do any sanctions. She didn't say that she was going to hold sanctions for later. Sanctions are monetary fines that lawyers get when they misbehave, and if you get a sanction, you have to report that to the state bar, to the legal bar, because you had a disciplinary action as a lawyer. But she didn't bring that up. She was just like, if something happens, you be candid with me. You bring it up to me. We can discuss it, but don't try to hide it from me. The last thing that we're going to touch on, I know this has been long, but it was a several days of court that we're compiling here, was that the Brady violations were not touched on yet. It doesn't seem like we're going to get there because the judge was like, yeah, we're not doing a continuance on this trial. We're going to start jury selection in just a couple weeks. I highly doubt that she is going to speculation because she hasn't made a ruling on it. I don't think she's going to dismiss this case. There's been too much time. If she was going to dismiss the case, she would have already done it. Okay, I think that if the Brady violations were strong enough about the Commonwealth not turning over information, if that was strong enough or convincing for Judge Cannone, she wouldn't have had to deal with all the rest of this. She could have cleared her schedule. I don't think that that's happening. It has not been ruled on as of yet, and we will see what happens from here. Thank you so much for joining me, my lovely humans. I know that it's late and I'm a little frazzle-brained and I was trying to read all my notes and stuff. But like I said, I'm a real person who's just an enthusiast and just trying to get this video out on Friday. So I will see you in the next video. Good night, sleep tight, and let us hope that justice is made right. I was trying to think of a non-bedbug rhyme. I'm tired. All right, bye, my lovely humans.